back into session for our 10:15 item. Oregon Department of Energy solar presentation. As I said earlier, this is for a presentation to the Board of Commissioners for us to get the guidelines. That's the advisory through the upsec process. Our planning director here is also, Darwin's here also. So there's been 2 projects with the notice of intent filed, the Blue Marmot and Obsidian up north. So with that, I'd like to welcome Ellen here and the director, Todd Cornett. Is that correct? And so I'll turn it over to you, give an overview, and we'll go from there.
No, I'm sitting up here, but Todd's gonna do the introductions.
That's appropriate.
Is this on or do you need to turn it on?
Is it?
Commissioner Winter, Chair Winter, Commissioner Kessner. For the record, my name is Todd Cornett. I'm the Assistant Director at the Department of Energy, and I manage the Energy Facility Siting Division. I want to thank you for the opportunity to come and present to you today. Helen is going to do the presentation, but I just wanted to start it and hit a couple of points. The first point being is this is the very beginning stage of our process. Our process will take some time. There'll be plenty of opportunities for participation. In terms of how our process is designed, it is designed, and Kellen will get into the details of this, but it is designed to include local government participation. Because the facility is located in your jurisdiction, you are an integral part of our process. So we'll be reaching out to you, seeking your input at several stages. And so it's important for us to make sure that you understand how to participate in the process. So whatever we can do to help you do that, to provide comments, to understand the issues, we're here to do that. We're happy to come back at any point you'd like us to come back and provide that information to you. So it's definitely a partnership, and you're an integral part of this process. Also, Helen has been receiving numerous comments from the public, obviously the people here in the audience. That's a great thing. That's also a very important part of our process. And so we encourage public participation. There'll be numerous points, which Helen will talk about, where the public can participate. We don't know everything. We work on the application, so as much public participation and comments that we can get makes it a better process, makes us able to identify things that need to be fully evaluated. So unless you have any questions for me, that's really all I wanted to say, and I'll turn it over to Helen.
I think as the board and as our director, we'll probably ask questions as goes. Is that acceptable for both of you?
Yeah, I think that'd be preferable.
Tip for the audience, can you just give a breakdown of the criteria that elevates it from local planning commission to?
I do have a slide
Okay.
of that in the presentation as well.
Yeah, and that's a good point, and Helen's been talking about that. Okay.
All right. Okay. Thank you, Todd. I think the microphone is on. I kind of talk loud anyway, so if anybody has trouble hearing me, let me know. For the record, my name is Kellen Tardyweather. I'm a senior siting analyst at the Oregon Department of Energy in the siting division. I am not here alone, as you know. I'm here with my assistant director, Todd Cornett. Max Woods is the senior policy advisor in the siting division. And then there's Rob Delmar, who's a senior energy analyst at the Oregon Department of Energy in the Bend office. And then I'm also, we're here with our communications department, Cliff Volva. He had to pronounce it for me. Additionally, I want to point out in the audience that there are representatives from the applicants for both of the facilities that we're going to talk today. So there's folks from Obsidian Renewables for the Obsidian Solar Center, if you want to go, hi. And then there's folks from EDPR for representing the Blue Marmot Solar Energy Facility, and they're there. And I do want to point out for the commissioners and also for the public that we're in no rush today. If we run out of time, we from Odo are going to stay afterwards to answer questions one-on-one from folks. And then the representatives from the applicants have also indicated that they're more than happy to do so as well. So we'll all be here afterwards to answer any remaining questions if people have them. Before I start, I also want to touch on a couple items. I put some handouts here on the table. And I gave them to Darwin, and if we need any additional copies, he can make copies. One of them is this really exciting and informational energy facility siting process flow chart. I'm gonna go over these in general, but this kind of breaks out each of the phases in our process a little bit more. The other one, I'm not sure if everybody would really want this handout. I also have a slide. It basically is directions how to access a new web map, which has like the GIS information or site-specific location for energy facilities, which again, I'll touch on that, but I just want to make a note of that now since I saw them going around. I'll have other resources with me, and when I get to this slide, I'll kind of touch on these. But I also do have just a hard copy of the notice of intent, the document itself, that is available online for both of the facilities if folks want to look through those. I'm just gonna get started. And then for the commissioners, I think that if you have questions on specific slides, ask them at the slide. However, I think I may punt the response because some of them may be found that I may discuss in later slides. All right, so the Oregon Energy Facility Siting Program, our primary purpose is to review all large energy infrastructure in Oregon. Depending on the type of energy infrastructure, there are different thresholds which would trigger whether or not it would go through the state review process. I'm going to talk about that as Commissioner Kessler referenced, specific to solar and those thresholds shortly. The Energy Facility Siting Council is a 7-person governor-appointed and state-approved council that is ultimately the decision maker on any recommendations that we as staff bring to the council. We, as the Oregon Department of Energy in the siting division, are staffed to FSEC, so we do the technical review, document drafting, and present to the council members any of the decisions or informational items that they may need to review. The FSEC, so when I refer to the Energy Facility Siting Council or council, I'm going to say FSEC. And you'll hear FSEC a lot, and there's going to be a lot of acronyms, so bear with me. We'll get through this. The FSEC review is what we call a consolidated review, and what that really means is all of the state permits that would be necessary for an energy facility that would be reviewed and permitted at a local level would now be encompassed within the FSEC review. The intent of a consolidated review is to eliminate duplicative efforts or duplication of any type of information or permits. It's to streamline the timelines, so there's consistent timelines. It's to also streamline decisions, so you don't have inconsistent decisions. And then the FSEC review also provides a single streamlined appeal process as well, rather than having several different appeal processes.
So there is an appeal process?
Yes, there is. I'm just going to click these last ones so we can see them, because I have additional slides where I'm going to talk about each of these a little bit more. The FSEC and ODO, the FSEC review is a standards-based review. I have a slide that touches on the vast majority of the council standards. And then there are, as Todd mentioned, several opportunities for public participation. And then I also have a slide that identifies the other phases as this handout does, which also will get into the application submittal and the review of those application materials and what our role is as a department and what the county's role is as a special advisory group, as well as other reviewing agencies. On this, I did want to note, because I have gotten some questions about questions and concerns regarding eminent domain and property seizures. I really want to point out that one, proceedings associated with eminent domain are, the process is through the Oregon Public Utilities Commission and approved through the commission, so that's an outside review. It's also reserved for public utilities and not private developers. So I wanted to point out that both of the applicants for both of the facilities that we're talking today are both private developers, so there aren't questions of eminent domain questions. On that note, also outside of the FSEC review process are proprietary questions. So this is land acquisitions, land leases, easements, all of those are negotiated outside of the FSEC process and done on behalf of the applicants. So I think that those are a couple of important notes. When we speak about siting and evaluating the siting of the facility, we're evaluating the potential impacts to the council, the applicable council standards. That said, here is a list of the 14 council standards that every project must meet to be approved by FSEC. So what the important thing to note here also is that there are other standards that may apply depending on the type of energy facility. So later on, I'm going to discuss the review that we request from the county and input that we request from the county primarily. And so these are the 14 standards. When I mentioned that there's an application that applicants submit that we review, that application is broken down into exhibits. There are more exhibits in the application than there are council standards. However, when we're doing our review and recommendations to council, we may pull information from several exhibits to use that information to potentially meet a particular council standard. So in general, the council standards that the county is really going to help us provide information for are land use and public services. The land use evaluation would be the evaluation that the county would conduct if they were reviewing the facility at the county level.
We also have an interest on the retirement and financial assurance.
Absolutely. There have been several questions in regard to, you know, who pays for what when the facility's done, and so we actually do. There is retirement and financial assurance, which illustrates how the applicant proposes to retire the facility, when they're proposing to retire the facility, and there's conditions written in to encompass and ensure that that facility will comply with those retirement proceedings. And additionally, there is the financial assurance, which indicates that there would be no financial burden on behalf of Oregonians, and we as ODO secure bonding to, for instance, if the applicant or certificate holder, if they received a site certificate, if they went bankrupt, left the state, we would have bonding to be able to pay to retire that facility or any of the associated cleanup to get it to its prior useful.
Non-hazardous.
What was it?
Non-hazardous.
Non-hazardous, thank you. All right, so as most of you know, and as the commissioners and Mr. Johnson know, that there have been solar facilities permitted at the county level. So why are we here now? We're here now because, as I had mentioned, depending on the type of energy facility, there are thresholds associated that would trigger the FSEC review. And really what we review as ODO and recommend to FSEC are impacts associated with large energy facilities. So there are triggers, whether it's megawatts, particularly when we look at solar, most of it looks at on-the-ground impacts of the facility. I tried to provide definitions for a lot of these acronyms here. So EFU is exclusive farm use, so this is the zoning designation for the land. So on EFU land, if the area is under 12 acres of high-value farmland, under 20 acres of arable land, or up to 320 acres on other land, it would be a conditional use permit issued by the county. And if it is over 12 acres, high-value farmland, over 20 acres arable land, but under 100 acres, it would be a county-issued conditional use permit and a Goal 3 exception. And then the third tier, oh, I think I even animated this. Oh, okay. Ooh. So over 100 acres, high-value farmland, over 100 acres on class 1 through 4 soils, or over 320 acres other land, then there would be a site certificate necessary and a Goal 3 exception for that facility. So that is, sorry, are we doing?
Well, I have a question on that, on number 3 there. Especially reviewing the map, those don't have to be contiguous properties to make that over 100 acres of high-value farmland.
It would be the total acreage associated with the site boundary. So even if, say, there was one square that maybe was 318 acres, but then a separate portion that maybe would be 5 acres, but they're proposing them together, and those together are over the 320 threshold, then that would trigger that. So it doesn't necessarily need to be contiguous lots, parcels.
What's a Goal 3 exception? I know, but a lot of people probably know.
Todd, could you actually?
Again, for the record, Todd Cornett, Oregon Department of Energy. A Goal 3 exception is related to protection farmland. So most of, at least most of our facilities, and probably many of the energy facilities in the county already, are located on exclusive farm use zone land. So the purpose of that land, the primary purpose of that land is for the preservation of farmland. So the Goal 3 is the Department of Land Conservation and Development's goal, which protects farmland. So there are thresholds that are established in the Department of Land Conservation and Development's rules, which is where these goal exception thresholds occur. And that's either 12 acres on high value, 20 acres on arable land, or 320 acres on any land. The idea there is that if you're taking 12 acres, whatever the thresholds are, out of permanent production or permanent opportunity for production, that you're no longer consistent with that goal of protecting agricultural land. And therefore, you have to go through this process, which it can be a fairly big burden to meet that process, showing why you should get an exception to that goal. So the difference that's probably worth noting is at the Department of Land Conservation and Development level, there are certain goal exception criteria. Ours are similar, but they're slightly different. So the one big difference in ours, and this may be getting too far into the weeds, but at least it kind of puts it out there to everybody, is there's an alternatives analysis required through the Department of Land Conservation and Development. So if an applicant came to you and it was within your jurisdiction, but you had to go through the goal exception process, you would be governed by the DLCD goal exception requirements, meaning the applicant would have to do an alternatives analysis showing why does that project have to be on that particular land, why can't it be on other areas. So there's some analysis that's required. Our process does not include that one portion. So an alternatives analysis is not required for our goal exception. And that's really the biggest differentiation. Did that answer, you asked the question, but did that answer the question?
Yeah, you mentioned a permanent loss of farm. Is that like forever, I assume, or is there a increment of time?
Commissioner Kessler, for practical purposes, these are all 30-year projects at least. So I think for the goal exception process, they're looked at as a permanent loss, permanent, not in perpetuity, but 30 years kind of falls within that range.
Thank you. All right, so this diagram, which the color doesn't come out fantastic on this front screen, but so this illustrates the phases associated with the FSEC and ODO review of applications. So as everybody's aware, and the reason why we're here is that several folks received a notice in the mail or saw it in the newspaper. We've been coordinating with the county because this is the notice of intent phase that is the first phase in the FSEC review. I've highlighted each of these blocks below and then you'll see which groups are associated with the review as we proceed forward in the other phases. So the notice of intent is submitted by the applicant, so the applicants initiate the notice of intent. It is in rule which outlines what they must submit. However, it is still preliminary. It is more of a scoping phase to get feedback from reviewing agencies, local governments, and the public about, feedback on the facility. So the reason why we're all here is precisely the intent of the notice of intent. There's also a public comment period associated with the NOI, and then there's agency coordination. I have the agency coordination block, and that means anytime we as ODO make a request to the county, tribal governments, or reviewing agencies, that's that agency coordination. So at the same time we're requesting public comments, we are also requesting comments from other agencies and governments. Yes?
On the public comment, you explained that at this stage is to gather information of concerns and so forth. And then down the road, as you indicated yesterday, there'll be another public comment.
Yes, there is, absolutely. Which, on that note, I don't have it right here, but I did provide, I have these public comment forms. This is if anybody wants to write a comment today. In general, if there's questions, we'd really like to answer the questions. And then I have kind of like, assistance with how to make public comments. We've gotten some really great public comments submitted in the mail and also emailed to me that really touch on issues that are significant to particular property owners, to wildlife, to other areas. So I appreciate the comments that have come in so far, but this is if anybody just kind of wants the contact information, wants to write a comment here. It's a written comment period, so that's just important to note for people that have called me. I really suggest send me an email, write a letter, because it's on the record for written comments that are submitted to the department. And I will touch on the other comment period as well.
And emails qualify.
Absolutely, absolutely. So once the notice of intent, once the comment period closes, and during this phase, we as the Department of Energy, we work on and draft a project order. The project order is a document which outlines the necessary permits and what the applicant will have to, the information they should provide associated with the exhibits in the application. Is kind of providing them an outline of the information that they should provide in their preliminary application, which leads to this application. And I have a PASC and an ASC. Applicants submit a preliminary application. So this is the draft of the application that is sent out to special advisory groups, also to reviewing agencies and tribal governments for their comment and review on the preliminary application. This is kind of inside, we call this the completeness phase. This is really where there is a back and forth of information. Special advisory groups, local governments, reviewing agencies submit what are called RAIs, requests for additional information, where they identify any insufficiencies in the application associated with completeness of what it says needs to be submitted in that application. Applicants respond, provide the information, and this may go back and forth until we as a department feel that the application is complete. What that means is that we feel that there is enough information based on comments, based on our analysis, our request for additional information, and with the assistance of our reviewing agencies, that we feel that there's enough information to be able to draft findings and provide them in this document, the draft proposed order, which then gets presented to council, which is the draft findings. So we'll get to that in a minute. So once the application is complete and we feel that there's adequate information in the application, then it becomes a complete application. The complete application is then circulated for distribution for kind of a final compliance review. And then from that information, as I just mentioned, there is a draft proposed order. So you'll see on here there's a comment period associated with this, and this is also another agency coordination block. So the DPO, or the draft proposed order, as I mentioned, is
Sorry.
Todd's gonna jump in here.
Yeah, I just want to make sure that, because there's one thing that got missed in here, which is at the completeness stage, we issued a completeness and do a completeness information meeting.
Oh, that's true. Oh, that's true. Yeah, so I had mentioned, and thank you, Todd. Commissioner Winters, you had asked that there is another opportunity, not only for public comment, but we require that applicants hold an informational meeting on the complete application, which is important and which is why we don't do information meetings on a preliminary application, and also why we make it or have it optional for the applicant to decide in the NOI phase. But why we do require it on a complete application is that we feel that it really is important for the public to be aware of what the final information looks like. What is the site boundary? What is the applicant proposing? And so that we will have informational meetings on the complete application, and then use the information in that complete application to draft the findings in the DPO. This DPO, and then there will also be, it says public comment, but there are public hearings on the DPO. This is a portion or a phase, and I'm not going to, we could talk forever about the intricacies of each of these, but the DPO phase is a really important phase because this is where the public has been able to review this. If there are outstanding issues that have not been addressed within the DPO, that's when members of the public, special advisory groups, reviewing agencies can make comments on the record hearing of the DPO. And then this also sets up later, which I'm gonna mention, the contested case. Yes.
Public hearings, will they be held within Lake County?
Absolutely. But the public hearings for each facility are supposed to be in the vicinity. And so really depending on when and if we get to those phases for both of these separate projects, they'll probably, you know, for instance, with the Obsidian Solar Center, it will probably be closer to the actual site of the facility, and this is just to make it easier for affected members of the public to participate.
Thank you.
Yeah. From the DPO, from those comments that are submitted on the DPO, we incorporate those comments into the proposed order. And then there is the issuance of the proposed order and notice of a contested case. And so at this point, the proposed order, if individuals or agencies that made a comment on the DPO that maybe was not addressed adequately, or they feel that it wasn't addressed adequately in the proposed order, if those, their specific comments had not been raised, they may request a contested case. Earlier when I had mentioned the FSEC process is the consolidated review, and one of the reasons behind them is that it's a consistent appeal path. The contested case is a proceeding where there's a third-party hearing officer that evaluates and provides findings in specific to those requests for a contested case. And the contested case may be ongoing. Also, any final orders that come out of the contested case may be appealed to the Supreme Court as well. Correct? Depending on when that process ends and how long it takes, or if there are any requests for contested case, the ending result would be in a final order and the issuance of a site certificate by the Energy Facility Siting Council. The site certificate is, well, frankly, a very large document that really outlines all of the permits, on all of the conditions necessary for the pre-construction, construction, operation, maintenance, and retirement of the facility. So it's a really big document that then, for compliance purposes, we have on record that really outlines everything that the applicant must do for each of those portions of the facility. Okay, so we have two proposed facilities that are under FSEC jurisdiction that the Lake County Board of Commissioners have been appointed by council at the last council meeting to be a special advisory group. I'm going to touch on specifically what those requests are, but one is the Obsidian Solar Center. So this is in North Lake County. It is proposed to, the site boundary is proposed to be up to 7,000 acres. As of right now, they are proposing to generate up to 600 megawatts of energy. There's a couple facility layouts that they are suggesting or proposing. They're also proposing a type A facility and a type B facility, or a combination of the two. The type A facility would just be a solar array, and the type B facility would be battery storage or components of battery storage. Again, I just want to reiterate that if there are lack of details that are found in this information, that is indicative of this notice of intent phase. It really is just kind of putting it out there. This is where we're thinking, this is what's being included. There are related or supporting facilities associated with the Obsidian Solar Center, including transmission lines. The POI is a point of interconnect. There's gen-tie lines, substations, access roads, and then temporary construction areas. It's important to note that all of those related or supporting facilities and the solar generating or the battery storage facilities themselves, everything would be within those site boundaries. And then the Blue Marmot Solar Energy Facilities, most of you are aware of, is located within and around the town of Lakeview. As of right now, the site boundary is proposed to be 5,170 acres, which seems very large. It is very large, and we do really want to indicate that the actual impacts and the actual site boundary later on, when they submit an application, it may be smaller, but the actual permanent impacts would be a lot less. The reason why it's so large is they're kind of saying, this is the area that we're going to evaluate for possible locations for gen-tie lines and some of these related or supporting facilities. There's 5 solar arrays that are located around the town of Lakeview, and then the other facilities that would be connecting them. It's proposed to generate up to 60 megawatts of electricity. I'm going to stop here on this map and point out, because again, the information contained in the NOIs, I'll put these over here, are available on our website. It is a little bit, they aren't labeled fantastically, but what I'd like to point out, because I actually have been getting several questions, and why I'm just going to take a moment to point this out here. So, and I'm going to point, this is the overview map. And if you live around where this facility is proposed, you kind of know what area you'd probably be living in. I'm going to pull out this map 25, which is right here. So this is a zoomed in location map. Again, this information is on the website. I've been getting a lot of calls and questions from folks, saying, oh, that the map provided in the notice just wasn't it wasn't accurate, it didn't tell me much, and I absolutely understand that. It's really hard to capture and provide a figure that says a lot in that notice that we send out, so we really want to point people to the website to look for more information. So this is that map 25, which has one of the proposed solar arrays, the Parmalee, and then the related, the connection lines associated with it. What I will, in this map, there is the diagonal hatched area is the facility site boundary, which includes those lines in the solar array. I guess I could use this to point. I wanted to show that this is this orange line is the 500-foot buffer from the facility site boundary. We can think about that kind of as like the noticing buffer. So some folks may have received a notice, but just because they're, even an edge of their property may have been within 500 feet of the site boundary. So I kind of wanted just to point out that that's what that orange line is. I'm gonna have these available afterwards, but just in case people are curious, I made copies, so I think there's 5 of each, so I have kind of like the big overview map, and then if you're in a particular area, I have, 5 copies of map 30, that if people wanted to take them home with them today, they could. So, and if you need help with that, I can help you with that. So I just wanted to make a note of that. I had mentioned that web map. So on our website, if you go to our website and facilities under FSEC, because everybody's so interested in all of our facilities, there is the list of all of our facilities that are under review, are operating, or perhaps even retired. We recently updated, and if there's this link right here, this is just a snippet, but there's a link right here. We'll see. Yay! So this may also be useful for the commissioners, but also for members of the public. So, oh, Melanie, can you type in OB? So there's up here on the tabs. Cool, thank you. Right, so if you know the facility that you're looking for, you can type in that particular facility and then be able to search around, see its proximity, and then if you're curious of other energy facilities that are under FSEC jurisdiction, there's also these color diamonds illustrate what type of facility they are, and then this tab shows the capacity. So you can kind of see the generating capacity of each facility relative to one another. And then could you, let me do BL. So this could be a useful tool for the public, for the county commissioners, just to kind of have a interactive interface to be able to search this. And this is generated from GIS information that's provided on behalf of the applicant.
Okay.
Yeah.
Go ahead.
I was gonna say, can you click into the dialog box which takes you then to the project page?
Oh, yeah.
So that people can see how to get to where all the information on the
So
project
if we click on this, so if we did the search, or if you click on this, if you go to the more info.
What is the web address you're looking at? I can't quite make it out.
Here, I have this copy right here. But it is through, really, if you just Googled FSEC Oregon, it would pop up to our project website. You keep that, sir. But, yeah, yes.
On the two projects, the one up north, we've got 3 distinct blocks. Down south has a more drawn out block with individual sites. What's the pros and cons of that second scenario? The local one.
The pros and cons of, let's see, how do I get back to my, there I am. It's difficult because it depends on what resources you're evaluating. So when we think and when we're doing our evaluation of the siting of a facility, we think about the on-the-ground impacts, the impacts to the potential, or the potential impacts to each council standard. So one could look at this facility and, again, the site boundary is larger than the actual, if it proceeds, what the permanent impacts would be. They're going to be significantly less than the site boundary. The site boundary is large because it's the applicant indicating this is the area of our consideration. So even though this looks more spidery and takes up more space, it may not have that many impacts, whereas, and again, it's a hard question to answer because it just depends on what the soil types are, what the wildlife, what the fish and wildlife, the potential impacts to fish and wildlife, impacts to cultural resources, and those are just going to be really contingent on the specific location. So it's hard you can't really compare the two. It really is site specific and depends on the evaluation of the site.
What's the distance between the furthest array on the bottom to the array in the west?
I'm not sure.
Ballpark.
Ballpark?
8 miles, 10 miles?
It is, let's see, 10 to 12 miles? Because you're saying from here to here.
I'm saying from there over to.
Oh, from here to here?
Yeah, probably 10 miles or so.
Yeah.
At least.
Yeah, well, yeah,
Air
12.
miles, it's every
12.
bit of 10.
Yeah, driving is more than that. And then, so, that's a pretty big range for arrays, right? I mean, pretty big distance.
It is, but you know, the actual areas where the arrays would be located are these.
Is any particular array more than 320 acres?
I'd have to ask the applicant, I don't have yeah.
Why are they, what is the indication of all these spaced out sites is that they look for more property, but these are the only places that would.
So we're sort of getting into specifics on a project, which I want to sort of hold off those questions for a little while so we get our guidelines. Appreciate the questions and they will be answered. What you guys are asking, sort of going back to how did they qualify with these little places all over the place? Going back to her slide, by the 12 acres of farmland and all that, apparently these qualified. And I think those are good questions to ask afterwards, but right now I want to be sure to stay on our process as commissioners. So,
Yeah, thank you, and then, so, I don't have the specific acreage for Maxwell's Mountain, yes, for each solar array, but one of them is larger than, and, even so, even if each, well, and I don't wanna get into hypotheticals, but the applicant is proposing them for all to be connected, and how we review an energy facility is the energy generation facility and the related or supporting facilities, and temporary construction areas, access roads, construction roads, we evaluate all of those. So even if those areas are included, that may be, we look at that as far as impacts of acreage.
So I going back to a question on the special advisory group, which that is Darwin and the Board of Commissioners, correct? Darwin's also designated as our planning director.
Right, and then we'll kind of get, we will get into that now, but the Lake County Board of Commissioners is designated as a special advisory group. Frequently, for the vast majority of our projects, the planning department, thank you, Darwin, does the vast majority of the work with the county in consultation, make sure that the county approves any of their comments or conditions or recommendations. There's a small provision that we'll get into when the county, or Darwin on behalf of the county, is submitting comments. We just need verification that the Board of Commissioners is acknowledging that Darwin is doing so on behalf of the special advisory group.
So our guidelines as public body and public meeting laws, those comments have to be basically approved by the board in a public meeting for them to go forward.
I think that would be, yeah.
That is our guidelines for
Please.
public meeting laws.
For the record, talking about the Department of Energy, that is entirely at your discretion. You can do that if the County Board of Commissioners themselves wants to evaluate that and put those forward, that is absolutely appropriate. However, you can delegate essentially that responsibility to Darwin, and he can do that on your behalf without going through that process. It really is your discretion of how you want to handle that.
Okay, and so, and I believe that's the direction, we're not planning directors, so we can probably give that direction either later today or maybe even tomorrow.
While you're on that subject, if we have a commissioner vote, and all three, then that's pretty obvious, if there's 2-1 or 1-2, whatever. How do you like to receive that information?
In terms of the local land use regulations and
So how comments?
It's just entirely how, I mean, we provide you kind of a format that we would like you to submit it in. However, you can choose different formats if you want.
However, the county themselves, the proceedings by which the county agrees to what the comments are is, as Todd mentioned, at your discretion. How those are submitted, for instance, for us, we don't necessarily need the minutes for how the county went through it. We assume that if the planning director on behalf of the county is submitting them, that the county has agreed upon by your own procedures of those. And once they're submitted to the department, that it is on behalf of the special advisory group in the county.
So we can make that happen easy enough. So and maybe I'm jumping out.
No, it's fine.
But one of my concerns, and I ask you this just for clarification, as a special advisory group, our guidelines, whenever on the normal process, when something is billed to the Board of Commissioners, we're quasi-judicial, so we can't talk to anybody but our staff. As a special advisory group, we're able to talk to the public, people come into their office, we're able to voice our opinions and everything because we're just an advisory group. Correct? Are there any guidelines
yeah.
that limit our interaction with our constituents?
No. Essentially, we're going to provide you, like we did at the notice of intent, a memo. So at some of the stages along the way that Kelly indicated, we're going to provide you, as a special advisor, a memo asking you for specific things. So this first one, was if you were reviewing this application, what are your criteria? What are your land use regulations? What are your comprehensive plan provisions? How would you review that? And if you have anything that's, subjective, how would you interpret that? So that's what we're looking for at this point in time. But you can absolutely solicit input from the public, if you want, whether that's individually or public forum. That's entirely you. You're not the decision maker in this instance. It's the Energy Facility Siting Council. So you are not governed by the same kind of limitations under what a typical quasi-judicial situation would be.
Thank you, yeah, that clarifies it.
Well, you did use one word that caught my attention, subjective. Anything that we recommend that has some subjectivity to it, we should know such for you. And if something is valid facts, then that'd be objective, and we should differentiate.
That is correct. I mean, land use regulations vary. You might have conditional use criteria that you have a whole body of decision-making history on how you've interpreted something. And if it's not plain on its face, it would be very valuable for us to get that interpretation. I mean, for you, you've done that evaluation however many times, you just know that you have that body of history and precedent when you're making those decisions. We don't know that. So anything like that, it will be helpful for us to know.
Is it appropriate or not appropriate for our actual planning commission to weigh in on this, or is that
It's entirely up to you.
entirely up to us?
Yeah, I think whatever you, so the biggest issue for us will be timeliness. So, we provide you a memo asking you to submit it within a certain time. We really need that information. We need that information kind of within that time frame. Beyond that, it is entirely up to you. So, whether it's entirely given to Darwin to be the one to do that, whether the commissioners want to do that, whether you want to solicit input from the public or have the planning commission evaluate, that entirely.
I'm probably jumping out there again.
No, it's fine.
Earlier I asked about there is an appeal process, and that appeal goes to who?
Goes to the Supreme Court from the contested case proceedings
Of Oregon.
Yes,
of Oregon.
Yeah.
Yes.
Or later on.
So-
The hearing's not
Criminal,
Sorry, it's the ALJ.
yeah. It's a different stream of
I see.
jurisdiction, is that
Yes.
correct? So
Yes.
it's a hearings officer.
Yes.
And we're mixing and matching here. So for our contested case, which is kind of like a pseudo built-in appeal process, that is an independent person. Could be an administrative law judge. It is not typically an administrative law judge. We hire independent contractors or attorneys who run that process, who are independent from us. That's one step in the process. If it gets appealed to the Oregon Supreme Court, that just goes through that process.
So there's opportunity for the developer, if they disagree, they can fill it, or if there's somebody that's opposed to the project that's approved, they can fill it at their own cost for their own legal counsel.
Correct. The applicant also has the rights in the contested case, if, the staff presents something that they don't agree with, they can raise that issue. They can also challenge that to the Supreme Court, just like a special advisory group or a member of the public.
Excuse me, if it is contested and it makes its way to the Supreme Court, does all proceedings cease and desist until a decision is made at the court level?
Well, the proceedings as in, those would need to be resolved prior to issuance of a site certificate or approval of the site certificate.
Yeah, I think it depends on if, as part of the appeal, it is, if the stay is requested and granted. So if you would, whoever's appealing to the Supreme Court would have to request a stay, and then the Supreme Court would have to request that stay in order for that, because it would have been a final decision by the Energy Facility Siting Council that was being appealed to the Supreme Court. So that's a valid decision. Without a stay, the developer has a valid site certificate and could begin construction.
All right, so we'll go on with the presentation.
Okay, thank you, Todd. Maybe you should just stay there.
I'll leave the exercise.
Take it away. So going back, and I think that we just, Todd just covered a lot of this, and you covered a lot of this with your questions, which are excellent questions, thank you. The role of the special advisory group is to submit the applicable substantive criteria. So this is criteria that's identified in the local land use plans and land use regulations, such as zoning ordinances. These are the criteria that apply to the facility and that the county would apply to the facility if they were doing their own jurisdictional review of it. As Todd mentioned, any local interpretations of those criteria, and then submit comments with compliance, any compliance issue, or identifying any other permits that would be necessary for compliance with them. And then we also do, as we had talked about, consultation for the vast majority of our projects. The planning department does assist with a lot of that. One of the notes is that the applicable substantive criteria can be submitted during this NOI phase. I believe in our request to the county, we did request that. When this really does apply, and what kind of sets the date of the applicable substantive criteria is the date of the submission of the preliminary application. And you'll receive a memo, if it does get submitted, you'll receive a memo that really has a specific outline request to this. But this is looking forward, what our request and what the role of the special advisory group is. So going back, and this is kind of the same request, this is more, the previous slide was what is the role in the process of the special advisory group. This is zoning into more of this specific notice of intent phase, and this is the request that we make of reviewing agencies and special advisory groups. We ask for the special advisory group to provide comments on the proposed facility, recommendations, a list of studies that may apply, particularly if they're of local knowledge and acknowledged, particularly in a land use plan. Statutes, rules, again, applicable substantive criteria. Somebody hung up on us. And then permits administered by the agency. This second one, recommendations regarding the size and location of the analysis area. We had an interagency meeting with Lake County and the other reviewing agencies yesterday, and this is specific, we kind of went over that. I had a slide breaking that out where I don't have that in this presentation today. But we do request that the county provide any insight about the proposed analysis area, and this is because those comments may be incorporated into that project order, which is that document that outlines what the applicant must submit post NOI phase. I'm just gonna kind of, I think I'm pretty much almost there, and a lot of this is specific for the county, and we did talk about it yesterday, but I'm not gonna breeze over it, so if there are any questions, what I would like to point out is this exhibit title and exhibits. These are all of the information as I had alluded to in the beginning when we were talking about the council standards and how there are exhibits in the application and how we as a department use information provided to us from reviewing agencies and information in these exhibits to draft the findings for, to meet or not meet council, the applicable council standards. So, again, definitely the one that we would be looking for input from the county, which would be land use. However, depending on the applicability of any of these other sections, the county may find it valuable to provide comments on those as well. We were talking about the format. This is when we get to the preliminary application, and we'll have another interagency and lots of conversations before that. The format by which the comments are submitted can be however is easiest for you, depending on how many comments there are. We do provide kind of this outline table where you say, where did we find the insufficiency, or we are requesting information? What's the rule by which, in your applicable substantive criteria, the location and what the actual comment is. And I can come back to this, but I'm just gonna wrap this up so we can kind of use our last few minutes for any questions that the commissioners have. Cost reimbursement, we've spoken about this, all of the work on review that when ODO requests the county to provide comment and review of our application materials or meetings associated with a specific facility, the county and county staff may be reimbursed for their work that they do for those projects. And then we've kind of coordinated with the planning department on that. I'm gonna let them do the driving.
Yeah. Well, I think, I asked the Hill timeline. The timeline since the notice of intent, and then get to the actual submission and all that. Both these projects on the fastest track, how fast could they be breaking ground?
Excellent question, really hard to answer. I want to point out here, each one of these different boxes is when, where we aren't driving the timeline, us as ODO. We have, in rule, we have specific timelines for some phases associated with the review and issuance of documents, and then there may be carve-outs for that. A lot of it really depends on this phase. No pressure, applicants. It really depends on the quality of a preliminary application and how adequate and sufficient the information provided in that application is. Did the applicant take the applicable substantive criteria and really do a full evaluation of everything that applies to the facility, or how did they address it in their Exhibit K? What's missing? So a lot of it depends on that. It depends on comment deadlines. How quick was Boardman Solar? It was about a little less, or a little bit over a year, correct?
Yeah, from 13 months total from the beginning. But that was also an expedited review because it was a lower megawatt facility, and so there was no notice of intent phase. So it started from the applicant submitting their application, but from beginning to end, that was 13 months. And there were no parties in a contested case. So that one was quite a bit faster.
Yeah, I have heard it takes about a 2-year time frame, and that seems like that's sort of fallen in place with these ones here, depending on, Kellen says, how good the application actually is how soon they actually get that in.
And Chairman, for clarification as well, that's our review time. So the applicants are there's no definitive timeline set, but applicants are typically given 3 years to begin construction. So at that point, there's a lot of variation about when they go to construction. If they do it within that 3-year time frame, if they ask for an extension, that really then is related to that project and its ability to actually get to that stage.
Okay,
And if I may, there was one other point that I thought was helpful to make, because this is all, the discussion is all about the application phase, because obviously that's where we're at. But I want to make a really important point to commissioners and the public. We are there for the life cycle of these facilities. So we have a compliance officer, that's all he does is compliance. So when these projects go into construction, we'll be there. We'll come down and frequent site visits to make sure that they're being constructed properly. When they're in operation, we'll come down and do a yearly site visit. They have an obligation also to submit annual reports to us. So it's not that, we come down here in mass at this phase and, you see us and then all of a sudden when everything's said and done, we disappear. We will be there for the life cycle of these facilities to make sure that they're built, operated, and ultimately retired consistent with the requirements that the siting council puts in place.
so I have one more, at least one more question. So the comment through the special advisory group, does it carry any more weight than just the general public? And I will elaborate a little bit, is I don't support irrigated ground going into the solar production. So if we put that on special advisory group, that our culture is we protect our farm ground. Does that carry any more weight than just the public putting that out there?
When the important item to note is that really the comments and evaluation and review that the county provides is the review that the county would conduct based on their own applicable substantive criteria from their land use regulations. So it depends on, for instance, your ordinances and those regulations or those plans, how that is carved out. But it would need to be consistent for it to be applied to meet the land use standard in the FSEC review, consistent with that criteria.
So with that said, we need to follow our criteria through our land use and zoning. So as an individual commissioner, I could do a public comment, even though I'm part of the advisory.
Yes.
Is that correct?
Yes.
Yeah, absolutely. And I think the big thing, as Kelly mentioned, it's a standards-based process. It's applicant's burden of proof to meet those standards, but if they can show in the record that they meet those standards, then they will get an approval. That's all, our whole process is to vet and make sure that they've submitted all that information. So I think the important point for the commissioners as well as the public is, certainly provide your comment, but you really need to tie them to the standards, because that's the decision-making factor. It's just like a conditional use permit that you review is, because people like it, or don't like it. It's good to hear that, but unless you can tie your issues or concerns to a standard to validate that standard has not been met, then we really don't have the opportunity to weigh the, kind of the opposition. It has to be related to a standard.
Okay. And we need to be consistent with our rules and our decisions in the past. Another question, the burden of cultural sites, wetland studies, historical sites, all that is a burden upon the applicant. When do they have to do that process? Is it before the application actually gets in, so that, let's say there's 300 acres and there's 100 acres of wetlands, it's not touchable. Do they have to have that study done before the application is accepted?
It would be before its application's deemed complete. So kind of going through, I'm gonna leave it here, but as we've had mentioned, there's a preliminary application. And then once kind of all the information's there, if it's all there, then it would be deemed complete. It's important to note that a complete application does not mean any type of approval. It just means that we as a department feel that there's adequate and sufficient information there for us to draft findings. That said, I'm going to point out here that there is a council standard for historic, cultural, archaeological resources, as well as, where is it? Looking for waters.
It's a fish and wildlife habitat.
There's fish and wildlife, and I can't see it.
I know wetlands is definitely
Is
an
it not
issue
on
that
there?
can, I don't know that it's on there. but
It's not on there. Okay, there is information that must be met. For instance, a wetland delineation must be conducted, and then if there's any proposed removal or fill permits, a removal and fill permit is under council jurisdiction. The Department of State Lands, who reviews wetland delineations and issues removal fill permits, same as at a locally jurisdictional level. Applicants would still have to go through that state process. That is just now governed by the site certificate, but all of that information would have to be provided prior to completeness.
Yeah, and wetlands can be mitigated, so that's one that can be mitigated.
Yep. Yep, and similar with the historic, cultural, and archaeological resources standards. So the archaeological surveys, all of these surveys and assessment would have to be conducted, provided to SHPO, which is the State Historic Preservation Office in Oregon. They review that information, designations have to be recommended, SHPO reviews that. So all of that information needs to be, for completeness, provided prior to completeness.
I did know the answer to some of them, I just getting it out there so they were
Just
answered.
make it, put me in hot seat.
Commissioner, you have some questions?
Yeah. The state agencies such as Department of Fish and Wildlife would weigh in on fish and wildlife habitat, endangered species, SHPO, et cetera, historic wildlife. Can you expand a little bit on the scenic resources and the public services?
Scenic resources and public services, absolutely. So scenic resources are resources that have scenic values that are identified and discussed in some sort of acknowledged planning document or plan. And that would be, yes. Well, the important part is, because really when we think about it from us being standards-based and really kind of being able to provide an evaluation, even though we all know that there are some resources that are scenic to us, subjectively we look through it more of an objective lens of having that associated, having it acknowledged, mentioned, evaluated, provided in some sort of planning document, management plans. That's really what we look for when members of the public or a county is identifying any potential impacts to scenic resources.
It needs to already be some document.
Yes. And then with public services, this would be, I also know, I'm not sure if anybody from Lakeview, from the town of Lakeview, is also designated as a special advisory group, because there are facility components designated within their city boundary. So, however, so we request that towns potentially, or cities potentially affected by a project, comment on any potential impacts to public services. So this is water, roads, waste treatment, any impacts associated with temporary facilities, housing, schools, hospitals, the fire department, and emergency services. So those are the public services that we request comments on, which would also be something that special advisory groups and counties comment on as well.
So probably the question I get asked the most is, it's going to be to devalue my property adjacent to it. How do you guys address that or evaluate that or even answer that question?
Todd?
I can't answer.
Thanks for throwing that one in. It's a good question. We have this question come up in other projects as well. There's a lot of wind projects in the kind of the Columbia Gorge area. We're limited to our standards. That's not a standard that, say, is in local county regulations. We don't have the ability to review that. So we don't have that sort of ability to do some sort of analysis of property value, increases or decreases. It's just not something.
Would a change in the zoning, if you had to change the zoning of that property, that could lead you toward that, changing that.
I'm going to just give,
I'm just telling
if it's taken out of exclusive farm use under conditional use, it gets back taxed 10 years by law. So yeah, it does change the zoning, or I don't know if the zoning is conditional use. I defer a little bit to the
Todd, and this is my first time going through this as well, so when you're taking a goal exception, you're not necessarily changing the zone. So that's where, the back tax 10 years thing would actually apply. That's more for like a non-farm dwelling type situation.
Correct. The vast majority of the exclusive farm use zone lands, are especially assessed for farm value. However, there are circumstances like a non-farm dwelling and the immediate property around that, or in this case, the solar facilities, that no longer is assessed at that value. We knew that it goes back to a certain point in time that they pay back taxes on that, based upon that no longer being specially assessed. But it's not technically a zoning change.
Do you have any other questions, Ken?
No. Something crossed my mind, but I kept on going.
So in your presentation, both of you are done at this point.
Okay.
So,
Yes, and as Kellen had mentioned, as long as people have questions, we're here to answer those questions.
so that's where I'm going now. What I would like to do, Commissioner concurs with me, is to close our public meeting and allow you to facilitate a meeting with all the residents that are here and the developers. Is that okay with you, Kellen?
It's fine. Would you prefer to do it in this context?
I think this is perfect. Commissioner, are you good with that?
Yeah, and if you're, just to note on that, which I think that I'll kind of make these available and kind of I'll re-explain what I have here. And then also just to kind of premise it with, we're very comfortable speaking to what we covered today. If there's real specific questions that are maybe project specific to each facility, then we would ask that maybe you have those questions for one-on-one with the applicants, just because that's we like speaking more to the process and what to expect and what to look forward to and opportunities to participate, etc. But if it's like a real specific project question, then there are representatives from the applicants. Maybe we can
So
get
there's
past
a
that
public meeting tonight
for the Obsidian.
for the
Okay.
Obsidian project.
So I want to ask both applicants, are you comfortable with that type of format for us to close our meeting and for you to answer questions?
Yeah, that's fine. I would just say that, in the interest of time, if people wanted to,
Your specific one, you got our
yeah,
information.
if you can't make it up to North Lake tonight, to ask questions there, then, of course, we're happy to answer questions here, but, there was a public meeting and an open house tonight.
For the-
Silver Lake High School from 6 to 8.
And then Will, you're here to actually answer questions, on it, correct?
Yeah, I want to emphasize that the Blue Marmot facility will also have a public hearing. It hasn't been public meeting, I'm sure.
Informational meeting?
Yeah, equivalent to what Obsidian is going to have tonight.
Do you have a date for that at this time?
So we've not yet scheduled it, and so part of what I'm happy to explain here today is what our likely timeline is for that and what we see as the pieces that we want to have in place before we schedule that. We can be here until noon, at which point we have to hit the road to catch a flight. We make ourselves available until then. I just want to make sure that people know that there will be ample opportunities to ask as many detailed project-specific questions.
Okay, so the sooner I close this meeting, the sooner people can ask. There was one other question over here, Ray.
I think I had a question kind of for you guys that may relate to Odo as well, but this is primarily a land use process that FSEC is going through to make a decision with regards to this. It'll be made by them at their level, outside of, with your recommendation, but outside of your decision making. But are there other decisions that will need to be made at the local level with regards to this? I just think back to some of the projects that we've looked at in the past have had property tax implications, and are there property tax incentive applications or decisions that will need to be made
You
at
must
the
have
local
missed
level
that
at some
part of our
point?
meeting today. We talked to the strategic investment plan and different things. Right now, it's sort of looking at, Ray, that most projects have come before us with the legislation of the pilot program, payment in lieu of taxes of $7,000 per megawatt. But there's three options. There's that, there's enterprise zone, and strategic investment plan.
So do you anticipate, I guess, that these projects are going to apply for some of those incentives in some manner or other, that you'll be making decisions on here?
We fully want to be fully engaged so that they give every bit they can to our communities.
Both tangible and intangible.
So we will adjourn at 11:30 and let you guys facilitate. If you want to set up here, you are.
Oh, no, I'm so comfortable.